What's going on, family and friends? Day 3 of the Linqto Bankruptcy Hearing focused on closing arguments, and more importantly, how each side framed the story of how we got here and what should happen next. At a high level, no new evidence was introduced. The evidentiary record is now closed. Today was about interpretation, credibility, and consequences. Counsel for the debtors, supported by the Creditors Committee and Special Subcommittee, emphasized process, regulatory risk, and practicality. They argued that the Chapter 11 filing was made in good faith, with input from both legal and regulatory advisors. Linqto was facing regulatory pressure, including subpoenas and potential enforcement actions, according to the debtors. At the time of the filing, the company lacked liquidity, operations had ceased, and cash reserves were minimal. According to the debtors, the reorganization plan aims to preserve as much customer value as possible while offering a path forward. They characterized the plan as a compromise to avoid prolonged litigation over ownership, rescission rights, and constructive trust claims. They further emphasized customers retain economic interest in underlying securities. Any claims relating to past conduct are preserved, not released. New management is not insulated from accountability, and oversight will continue through trustees and court supervision. The Unsecured Creditors Committee, who are promoters of the plan as well, also pointed to the voting results, noting significant support from those who participated, approximately only 40% of Linqto's customer base. As part of the Linqto Chapter 11 proceedings, Forge was selected to manage the liquidation trust, while Van Eck will oversee the closed-end fund. During the closing arguments, counsel for the debtors, Schwartz Law, described this arrangement as an opportunity for Linqto customers, emphasizing Forge's platform capabilities, its built-in customer base of over 750,000 users, and the potential for instant liquidity. Linqto, the company, had over 1 million users on the platform, in addition to 14,000 invested members worldwide. And Linqto also pioneered liquidity in the private sector, meaning not only could you purchase SPVs tethered to pre-IPO investments for minimums as low as $2,500, but you could sell your position whenever you please. A prose statement from Gavin Solomon, a Linqto customer and shareholder, raised important concerns about Forge's trajectory. Mr. Solomon reminded the court that Forge was once valued over $2 billion, but now trades at a significantly reduced market cap of only around $610 million. These realities should not be overlooked, especially when considering how customer assets will be managed and monetized going forward. While Forge and Van Eck bring institutional experience, questions about execution, valuation risk, and platform trust remain wide open, especially for those of us who entrusted Linqto with significant amount of capital. A recurring issue that was brought up were the fees that us customers will incur due to the proposed plan. It was acknowledged by the debtors' counsel on record that the 5% administrative fee is only an estimate. It's not a hard cap. Actual fees may vary depending on how long this administration and related litigation continue. So to confirm, there's no fixed ceiling on expenses, although efforts are being made to manage them. Linqto customer and shareholder Gavin Solomon argued that this bankruptcy was strategic and not strictly necessary. Governance failures and conflicts of interest contributed to this filing. Certain new management figures, especially those with deep ties to competitors like Nickel, should not oversee the restructuring. Customers should not bear the financial burden of problems they did not create. Former CEO Bill Saris, legal counsel, also raised concerns about whether the authority to file the bankruptcy was properly granted, even the timing of the filing, and the extent to which existing leadership were excluded from the decision-making. At several points, Judge Alfredo Perez asked Bill Saris, legal counsel, to link their arguments directly to evidence in the record. In a way, Judge Perez got a little bit heated, a little bit combative, which we didn't see that kind of behavior when counsel for the debtors approached the stand. One of the most compelling moments during the hearing today were comments made by the attorney John Deaton, who's representing thousands of customers. John had highlighted the financial and emotional toll that these everyday investors and retirees are feeling right now because of this case. He raised the concern that further litigation could erode remaining value for customers, and that supporting the plan is not necessarily an endorsement of management, but a recognition of practical realities. No ruling was issued at the close of day 3. The judge took the matter under advisement. Options now include confirming the plan, dismissing the case, or requesting modifications. What became clear is that the factual record is now substantial. Governance, conflicts of interest, and asset ownership concerns are squarely before the court. The judge must now weigh legal standards against pragmatic outcomes for stakeholders. So the case didn't end today, but now all facts are before the judge in clear terms. As we wait for a ruling, the court questions shift from what happened to what's fair, what's feasible, and what's legally sound. So keep your head on a swivel, family and friends. We're coming to an end in this Linqto bankruptcy saga. Friday will be here before we know it. Thanks for tuning in. Love you mucho.